Iain, you've grappled with the use of international mechanisms to advance economic and social rights. How should we think about the enforcement of decisions that come out of international mechanisms, such as the international covenants, the committees in Geneva?
Well, we should be very worried, I think. That's what we should be thinking, because for many parts of the world, and I think one of the things obviously missing from this conference in a way is the kind of the Asian perspective. I think, sort of the Far East Asian perspective and the Pacific perspective, because in many parts of the world, as you said, there is no regional mechanism, and one of the problems I think now that we have with mechanisms, international mechanisms that are largely civil and political mechanisms, is actually getting effective enforcement. And we've been involved in some Human Rights Committee litigation going back 10 years in the Caribbean on fair trial and people on death row, and I've recently been involved in some cases in South Asia with people who have been arbitrarily detained, and you get the decision handed down, and it's a bit like what Mark was saying yesterday vis-a-vis getting the Constitutional Court case, and Jeff can speak better this on me, but on the treatment action campaign, ensuring that actually that the court decision is properly enforced. But I think it's doubly difficult at the international level, and it means, I think, in terms of process, in terms of, and it's an internal debate we're having at the moment, of an ongoing commitment to seeing effective implementation. But when you're an international NGO, that's obviously there are additional barriers to that, and you've obviously got to work very much with the local people on the ground, because certainly those cases that we worked on 10 years ago in the Caribbean, and great, we won the case, so no doubt we got lots of publicity and funding on the back of it, but those poor guys are still locked up in some hellhole in Trinidad or in Jamaica, even though the Human Rights Committee in its wisdom said they were denied a fair trial. So coming on to economic and social rights, and as Colm's already said, one should not underplay the challenges there. So although I'm in a working group that's trying to get a similar complaints mechanism to the International Covenant on Economic and Social Rights, which I think is important, I think it's important for two reasons. I think because it provides that extra avenue of redress, and I think it's symbolic. Why is it the fact that we had a universal declaration that has both sets of rights in it, and then we have the two sister covenants which have very similar provisions, similar clauses, and yet we have one mechanism that is clearly less, seem to be of less value. And I think it is interesting, we are still having these debates. It is interesting that very senior American lawyers are saying what they are saying, and you've got an example of that I note in your conference pack from somebody who is known, I think, to many of you. So, I think it is strange. I mean, in many parts of the world, they would see this as a strange discourse, and I think particularly in countries like India, where there has been this judicial activism, and again, that is in other jurisdictions is seen as something that is overreaching the separation of powers. And I think there are legitimate questions to be had, but I think there are benefits from the Indian court approach that are worth following, that has an impact on the international level. I think it's about the courts themselves, which they do in India, of continued monitoring of implementation of their own decisions, of actually sometimes laying out quite detailed blueprints for implementation. So there's a case from West Bengal where a guy was denied emergency medical treatment. They took him around to about 14, poor guy, took him around about 14 hospitals, and he still couldn't get A&E treatment, accident, emergency. And so eventually he had to go into a private hospital, and he claimed compensation. Now, not only did they give him redress for that case, what they also said was, this is the kind of emergency treatment mechanism you should have in place as a local health authority. And they laid actually down quite a detailed blueprint for that. How did they do that? Well, they often use expert committees. They will often get expert reports and evidence, as much as you do in a civil case on a particular matter. And as Jeff said, the judges don't have to be the experts necessarily on the case, but what they have to do is apply judicial principles.
But this Indian approach of providing very detailed blueprints for what should be done, doesn't that in a way contradict the South African approach, which is we'll determine whether or not it was reasonable, but we're not getting into the kinds of treatment or the kinds of steps that should be taken? Well,
I think there are legitimate questions to be had about the benefits of it. I think what I would say is, in terms of, I think, the Indian approach, is the courts have seen over a number of years, in their view, is that the executive, and often you're dealing with, local state governments as much as central government, are not in a position, as far as they see it, to come out with solutions. So they, in a way, are coming up with the solutions themselves. Now, maybe, as I said, if they're doing that really off their own bat, and I have to say some of them do that sometimes, and some of the judges may well think that they are experts on these issues, and they will actually lay out a detailed thing, and maybe there are contested areas there about overstepping the mark, but often they will have done it based upon quite considered evidence of getting leading people in the field to come up and provide expert reports, which they will then draw on. So I think that the combination of the creative application of guarantees like the right to life in the Indian Constitution, combined with opening up the public interest, litigation, access to justice, I think it has done a lot, at least, for promoting economic and social rights. But I would hark on about this issue about monitoring and implementation, which I think is very important. And often, and it has been known that the Indian courts will hold officials in contempt, because ultimately you need some kind of sanction. Because you see, if you look at Indian jurisprudence, you will see the same case keep on coming back to court, the same names, and you're trying to scrabble around and actually find out, well, where is the case now in terms of progress? And they keep on holding it, and eventually they may well hold officials in contempt if they have willfully failed to comply with court decisions. Again, it's about what have they reasonably done. So there is a lot of commonality, I think.